Hello, Year 11. So I have some time this evening. I'm going to record you another video. Why not? I'll also upload the slides for this one. I realized I didn't do that yesterday, and maybe that was difficult for some of you. I don't know. Either way, the slides will also be up, but I'm just going to record this video, and hopefully your teacher's playing this for you right now. So the primary role, also, we're going to be looking at the sources of law today, and that there are two different sources of law, two different places that we can get law from. That is the Parliament or the statute law, and it is the courts or common law. So we'll go over this again and we go into each of those in a bit of detail, and then we're going to look at some case studies. But let's start with statute law. So the primary role of Parliament is to make law, and laws are made by Parliament, or laws that are made by Parliament, sorry, are called statutes or acts of Parliament or legislation. So they do this through creating bills, and a bill is basically just a proposal for a new idea for a law, whether it be a new law or an amendment to a law. But before a bill can become a law, it has to pass through both houses of Parliament. You can see them pictured on screen now. Then it's presented to the Governor-General, who's the representative of the King, and they are tasked with the power to provide the King's approval to pass such a law. And that approval is called royal assent. They set a date for the law to begin taking effect, and then from that date, the law is going to be in effect. We also have common law, which is the other source of law. And this originates in the courts. It's formed through judges making decisions on cases, and those statutes that we were referring to previously, the statute law, they must be interpreted by a judge as to how they will apply in the real world. And that process is called statutory interpretation. You can see it on screen now. A judge doing so may create common law in the process. So, for example, the Deng v. Tarola case, which we'll review later. Next, we have precedent. And this is where a court is the first to hear and make a decision on a new issue brought before it when there's no legislation in that area. So when something new is brought in front of the courts, they need to be able to make a decision on that, a legally binding decision on that. That's the purpose of the courts. Sometimes there's going to be something brand new, they'll never have heard it before, but they still need to make a decision. When they do that, they're creating precedent. Now, there's some different types of precedent, and we're going to go into those now. So, legal precedents are established through court decisions, like I was just saying. The most important part of the judgment's the reason for the decision, or ratio decidendi, which literally just means the reason. The operation of precedent means that lower courts in the same court hierarchy will follow that ratio decidendi, meaning if the Supreme Court makes a decision on something, then the county court, the magistrates court, they must follow that ratio decidendi. That is a binding precedent. And stare decisis is where they must, or means literally just to let the decision stand. We're not going to use that too much, but we'll move along to the different types of precedent now. These you will need to know. So there are two different types of precedent. So we have binding and persuasive. Binding precedents must be followed by courts that are lower in the same court hierarchy. Like I was saying, the Supreme Court makes a decision, the county court, the magistrates court, they must follow it. Persuasive precedents don't have to be followed, and courts can choose to follow them. There are four main ways that courts can develop or avoid earlier precedents, and those are outlined for you on screen now. If you're interested, I'd recommend having a read of those because it gives you a lot more detail as to how precedent functions. I'm not going to be testing you on those specific details right now. I wouldn't worry about that at the moment. So to summarise, we have two main places in Australia that law can originate. Statute law originates in Parliament, common law originates in the courts. Statute law is generally steered by the government at the time and is created by whatever the Parliament really sees fit. It begins as a bill, passes through both houses of Parliament, or must in order to become law, and requires royal assent, which is provided by the King's representative or the Governor-General to become the law. Common law, on the other hand, is often created in response to cases or seen before the court. So a judge cannot create law based on whatever they see fit. There has to be a case that they are hearing on which they must make a decision, which is when they can make a decision that creates new common law. And this means where they have to interpret a statute, so where there's statutory interpretation taking place, or when they're making a decision on a new issue that doesn't have any relevant statute covering it. It also does not require the King's approval to become a law. So that's some of the differences and similarities between statute and common law. Now, what I want you guys to do is I'd like you to turn to the questions at the back of page 3.4 and complete questions 1 to 5. To the teacher who is taking this class, I'd like you to give them around 15 to 20 minutes to do that. It shouldn't take them that long. They can do them pretty quickly. If they put their mind to it, I think they can get them done in under 10, but give them 15 to 20 anyway. After that, you can unpause this video and I'll go through the case study that they're going to work on in the second half of this lesson. Thank you. All right, I expect that everyone completed those questions now. We're moving on to the case study for today, which is the snail in the bottle case, or Donoghue v Stevenson. This is actually a case from the UK. However, Australia derives a lot of its common law from the UK's common law. So we do use a lot of the same sorts of laws that the UK does. This is Donoghue v Stevenson from 1932, and it is an extremely famous case. So I'm just going to read it now to you guys, and then you're going to complete question 6 in its entirety. And then after that, you're going to do question 7, which involves you looking at the Dane v Torolla case. You guys are already familiar with that one. Most of you should be. Nonetheless, we're going to go through this one together now. Some of you may have already seen it before. Elena, I know you have. So this is one of the most famous precedents in common law. It's the British case of Donoghue v Stevenson. It's commonly known as the snail in the bottle case. So May Donoghue, the plaintiff in this case, went to a cafe where she was given a ginger beer. The bottle of beer was bought by a friend of hers and poured into a glass for her. After Donoghue had drunk half the contents of the bottle, a decomposed snail was poured out into her glass. The snail could not be seen before the ginger beer had been consumed because the bottle was opaque, meaning it was not clear, it wasn't see-through. So Donoghue became ill and as a result later suffered from severe gastroenteritis. Donoghue did not have a contract with the cafe or the manufacturer because she didn't buy the ginger beer herself. It wasn't her and the contractor or her and the cafe that had this contract of sale. The ginger beer was bought for her. So this meant that she couldn't sue for a breach of contract. Instead, Donoghue claimed the manufacturer of the ginger beer, David Stevenson, had been negligent in the washing of the bottles before filling them with ginger beer. She sued Stevenson, alleging he failed in 2 ways. First, that it was the duty of the manufacturer to provide a system that would stop snails from getting into his ginger beer bottles. Second, it was the duty of the manufacturer to inspect the bottles before filling them with ginger beer and selling them to the customers. Now, Donoghue's initial case actually failed. She wasn't successful. However, she was granted leave to appeal to the House of Lords, where it was found that the manufacturer had been negligent. Because the bottle was opaque, Donoghue didn't have any reasonable opportunity to check the bottle's contents before drinking it. If you can't see into a bottle, for example, a can, if you open a can, you can't see through that. You would expect, however, that the contents that are on the label are what's in there, not something else that might make you sick. And if you don't have an opportunity to check what's in the can, that's not really on you for this occasion. So because the bottle was opaque, she didn't have an opportunity to check the bottle's contents before drinking it. The court ruled that Stevenson failed to take reasonable care in supplying a product that he knew would be consumed with no reasonable opportunity for the distributor, retailer, or consumer to inspect the goods before consumption. Basically, if you sell a product that is going to be supplied in an opaque container, a container that cannot be seen through, you need to take reasonable care when supplying that product. You need to understand that the product that you're supplying, people are not going to be looking at it. There's no expectation that you should open a can that you purchase at 7-Eleven and pour it into another clear container, like a glass, before drinking it. That's not common. So this was the beginning of a series of cases that established various legal principles around when one person may be negligent towards another person, and in particular when one person may owe a duty of care to another person. So this is an example of common law being made by the courts. So originally, under the statutes and everything, her case was not, she was not successful. However, she was given the opportunity to appeal to a higher court, which is the House of Lords, and there they established that actually, yes, it is negligent of the supplier of this ginger beer, the manufacturer of this ginger beer, to provide ginger beer in such a manner that is not able to be checked, and also not take these checks to make sure that their bottles that they're providing are not clear or are not safe to drink from. So this is a really, really famous case. And now what I want you guys to do is I want you to work through question 6 in chapter 3.4. Complete the questions for question 6. And then when you're done with this, the work that you have to complete for the rest of the lesson is question 7. Now, a lot of you, again, who have taken Year 10 legal studies and have had me for a teacher or Mr. Rami for a teacher last year will be familiar with the Dane v. Tyroler case. We use it in Year 10, and we use it intentionally because we know that we will use this case again in Year 11. Go and have a look at the Dane v. Tyroler case, which is in chapter 3.4, and complete the questions for question 7. That is your homework for tonight. Complete it now so you don't have any. That's my advice. Looking forward to seeing you guys next week. I'll bring plenty of photos of my little dude when I am back. Thanks, guys, and complete question 6 and question 7. That's what you have for the rest of the day. Thank you.